Hey folks, Attorney Andrew Branca for the Law of Self-Defense. Thank you for joining me for our ongoing four-part reading of the famous U.S. Supreme Court decision, Miranda v. United States, which gave us the Miranda rights we're all familiar with from TV and movies, specifically that you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney and to have that attorney present during interrogation. And if you cannot afford an attorney, one will be appointed for you. Now, this is part 2 of our 4-part reading. So if you haven't yet gone through part 1, obviously that's where you should start. There's a link to that in the description. If you haven't gone through part 1, then you're in the right place. So here we go with our reading of the second half of the majority opinion in Miranda v. Arizona. Enjoy. Today's show is sponsored by the Law of Self-Defense, specifically our advanced live online class taking place on April 20th, 2024. This is our full-day course on use of force law that makes you hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We cover everything you need to know. Why and how the legal system prosecutes self-defense, the 5 elements of self-defense, the fundamental building blocks of any claim of self-defense. We cover defense of others and defense of property, consciousness of guilt, self-defense immunity. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event, how to craft your own customized, legally sound self-defense strategy, and much, much more. Now, we only teach this class twice a year at most. So if you miss this April course, it'll be at least 6 months before you have the opportunity to take this course again and make yourself hard to convict. Do you know when you're going to be attacked? It's not up to you. The bad guy chooses the time, place, and manner of attack. You need to be ready for both the physical fight and the legal fight before that happens. And register now, and you can get up to 50% off for this April 20th Law of Self-Defense live online advanced course. Don't hesitate. Scan that QR code now, or simply visit lawofselfdefense.com/advanced. Part 3 of Miranda v. Arizona. Today, then, there can be no doubt that the Fifth Amendment privilege is available outside of criminal court proceedings and serves to protect persons in all settings in which their freedom of action is curtailed in any significant way from being compelled to incriminate themselves. We have concluded that without proper safeguards, the process of in-custody interrogation of persons suspected or accused of crime contains inherently compelling pressures which work to undermine the individual's will to resist and to compel him to speak where he would not otherwise do so freely. In order to combat these pressures and to permit a full opportunity to exercise the privilege against self-incrimination, the accused must be adequately and effectively apprised of his rights, and the exercise of those rights must be fully honored. It is impossible for us to foresee the potential alternatives for protecting the privilege which might be devised by Congress or the states in the exercise of their creative rulemaking capacities. Therefore, we cannot say that the Constitution necessarily requires adherence to any particular solution for the inherent compulsions of the interrogation process as it is presently conducted. Our decision in no way creates a constitutional straitjacket which will handicap sound efforts at reform, nor is it intended to have this effect. We encourage Congress and the states to continue their laudable search for increasingly effective ways of protecting the rights of the individual while promoting efficient enforcement of our criminal laws. However, unless we are shown other procedures which are at least as effective in apprising accused persons of their right of silence and in assuring a continuous opportunity to exercise it, the following safeguards must be observed. At the outset, if a person in custody is to be subjected to interrogation, he must first be informed in clear and unequivocal terms that he has the right to remain silent. For those unaware of the privilege, the warning is needed simply to make them aware of it, the threshold requirement for an intelligent decision as to its exercise. More important, such a warning is an absolute prerequisite in overcoming the inherent pressures of the interrogation atmosphere. It is not just the subnormal or woefully ignorant who succumb to an interrogator's imprecations, whether implied or expressly stated, that the interrogation will continue until a confession is obtained, or that silence in the face of accusation is itself damning and will bode ill when presented to a jury. Further, the warning will show the individual that his interrogators are prepared to recognize his privilege should he choose to exercise it. The Fifth Amendment privilege is so fundamental to our system of constitutional rule, and the expedient of giving an adequate warning as to the availability of the privilege so simple, we will not pause to inquire in individual cases whether the defendant was aware of his rights without a warning being given. Assessments of the knowledge the defendant possessed, based on information as to his age, education, intelligence, or prior contact with authorities, can never be more than speculation. A warning is a clear-cut fact. More important, whatever the background of the person interrogated, a warning at the time of the interrogation is indispensable to overcome its pressures and to ensure that the individual knows he is free to exercise the privilege at that point in time. The warning of the right to remain silent must be accompanied by the explanation that anything said can and will be used against the individual in court. This warning is needed in order to make him aware not only of the privilege but also of the consequences of foregoing it. It is only through an awareness of these consequences that there can be any assurance of real understanding and intelligent exercise of the privilege. Moreover, this warning may serve to make the individual more acutely aware that he is faced with a phase of the adversary system, that he is not in the presence of persons acting solely in his interest. The circumstances surrounding in-custody interrogation can operate very quickly to overbear the will of one merely made aware of his privilege by his interrogators. Therefore, the right to have counsel present at the interrogation is indispensable to the protection of the Fifth Amendment privilege under the system we delineate today. Our aim is to assure that the individual's right to choose between silence and speech remains unfettered throughout the interrogation process. A once stated warning, delivered by those who will conduct the interrogation, cannot itself suffice to that end among those who most require knowledge of their rights. A mere warning given by the interrogators is not alone sufficient to accomplish that end. Prosecutors themselves claim that the admonishment of the right to remain silent without more, quote, will benefit only the recidivist and the professional, close quote. Even preliminary advice given to the accused by his own attorney can be swiftly overcome by the secret interrogation process. Thus, the need for counsel to protect the Fifth Amendment privilege comprehends not merely a right to consult with counsel prior to questioning, but also to have counsel present during any questioning if the defendant so desires. The presence of counsel at the interrogation may serve several significant subsidiary functions as well. If the accused decides to talk to his interrogators, the assistance of counsel can mitigate the dangers of untrustworthiness. With a lawyer present, the likelihood that the police will practice coercion is reduced, and if coercion is nevertheless exercised, a lawyer can testify to it in court. The presence of a lawyer can also help to guarantee that the accused gives a fully accurate statement to the police, and that the statement is rightly reported by the prosecution at trial. An individual need not make a pre-interrogation request for a lawyer. While such request affirmatively secures his right to have one, his failure to ask for a lawyer does not constitute a waiver. No effective waiver of the right to counsel during interrogation can be recognized unless specifically made after the warnings we here delineate have been given. The accused who does not know his rights and therefore does not make a request may be the person who most needs counsel. As the California Supreme Court has aptly put it, quote, finally, we must recognize that the imposition of the requirement for the request would discriminate against a defendant who does not know his rights. The defendant who does not ask for counsel is the very defendant who most needs counsel. We cannot penalize a defendant who, not understanding his constitutional rights, does not make the formal request, and by such failure demonstrates his helplessness. To require the request would be to favor the defendant whose sophistication or status had fortuitously prompted him to make it. Close quote. In Carnley v. Cochran, U.S. Supreme Court, 1962, we stated, quote, it is settled that where the assistance of counsel is a constitutional requisite, the right to be furnished counsel does not depend on a request. Close quote. This proposition applies with equal force in the context of providing counsel to protect an accused Fifth Amendment privilege in the face of interrogation. Although the role of counsel at trial differs from the role during interrogation, the differences are not relevant to the question whether a request is a prerequisite. Accordingly, we hold that an individual held for interrogation must be clearly informed that he has the right to consult with an attorney and to have the attorney with him during interrogation under the system for protecting the privilege we delineate today. As with the warnings of the right to remain silent and that anything stated can be used in evidence against him, this warning is an absolute prerequisite to interrogation. No amount of circumstantial evidence that the person may have been aware of this right will suffice to stand in its stead. Only through such a warning is there ascertainable assurance that the accused was aware of this right. If an individual indicates that he wishes the assistance of counsel before any interrogation occurs, the authorities cannot rationally ignore or deny his request on the basis that the individual does not have or cannot afford a retained attorney. The financial ability of the individual has no relationship to the scope of the rights involved here. The privilege against self-incrimination secured by the Constitution applies to all individuals. The need for counsel in order to protect the privilege exists for the indigent as well as the affluent. In fact, were we to limit these constitutional rights to those who can retain an attorney, our decisions today would be of little significance. The cases before us, as well as the vast majority of confession cases with which we have dealt in the past, involve those unable to retain counsel. While authorities are not required to relieve the accused of his poverty, they have the obligation not to take advantage of indigence in the administration of justice. Denial of counsel to the indigent at the time of interrogation, while allowing an attorney to those who can afford one, would be no more supportable by reason or logic than the similar situation at trial, and on appeal struck down in Gideon v. Wainwright, 1963, and Douglas v. California, also 1963, both Supreme Court decisions. Gideon is a Supreme Court decision that mandated that if you can't afford a lawyer, one will be appointed to you. Back to the decision. In order fully to apprise a person interrogated of the extent of his rights under this system, then, it is necessary to warn him not only that he has the right to consult with an attorney, but also that if he is indigent, a lawyer will be appointed to represent him. Without this additional warning, the admonition of the right to consult with counsel would often be understood as meaning only that he can consult with a lawyer if he has one, or has the funds to obtain one. The warning of a right to counsel would be hollow, if not couched in terms that would convey to the indigent, the person most often subjected to interrogation, the knowledge that he too has a right to have counsel present. As with the warnings of the right to remain silent and of the general right to counsel, only by effective and express explanation to the indigent of this right can there be assurance that he was truly in a position to exercise it. Once warnings have been given, the subsequent procedure is clear. If the individual indicates in any manner, at any time, prior to or during questioning, that he wishes to remain silent, the interrogation must cease. At this point, he has shown that he intends to exercise his Fifth Amendment privilege. Any statement taken after the person invokes his privilege cannot be other than the product of compulsion, subtle or otherwise. Without the right to cut off questioning, the setting of in-custody interrogation operates on the individual to overcome free choice in producing a statement after the privilege has been once invoked. If the individual states that he wants an attorney, the interrogation must cease until an attorney is present. At that time, the individual must have an opportunity to confer with the attorney and to have him present during any subsequent questioning. If the individual cannot obtain an attorney and he indicates that he wants one before speaking to police, they must respect his decision to remain silent. This does not mean, as some have suggested, that each police station must have a station house lawyer present at all times to advise prisoners. It does mean, however, that if police propose to interrogate a person, they must make known to him that he is entitled to a lawyer, and that if he cannot afford one, a lawyer will be provided for him prior to any interrogation. If authorities conclude that they will not provide counsel during a reasonable period of time in which investigation in the field is carried out, they must refrain from doing so without violating the person's Fifth Amendment privilege, so long as they do not question him during that time. If the interrogation continues without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his privilege against self-incrimination and his right to retained or appointed counsel. This court has always set high standards of proof for the waiver of constitutional rights, and we reassert these standards as applied to in-custody interrogation. Since the state is responsible for establishing the isolated circumstances under which the interrogation takes place and has the only means of making available corroborated evidence of warnings given during incommunicado interrogation, the burden is rightly on its shoulders. An express statement that the individual is willing to make a statement and does not want an attorney, followed closely by a statement, could constitute a waiver. But a valid waiver will not be presumed simply from the silence of the accused after warnings are given, or simply from the fact that a confession was in fact eventually obtained. A statement we made in Cornley v. Cochran, U.S. Supreme Court 1962, is applicable here. Quote, presuming waiver from a silent record is impermissible. The record must show, or there must be an allegation and evidence which show, that an accused was offered counsel, but intelligently and understandingly rejected the offer. Anything less is not waiver. Close quote. Moreover, where in-custody interrogation is involved, there is no room for the contention that the privilege is waived if the individual answers some questions or gives some information on his own, prior to invoking his right to remain silent when interrogated. Whatever the testimony of the authorities as to waiver of rights by an accused, the fact of lengthy interrogation or incommunicado incarceration before a statement is made is strong evidence that the accused did not validly waive his rights. In these circumstances, the fact that the individual eventually made a statement is consistent with the conclusion that the compelling influence of the interrogation finally forced him to do so. It is inconsistent with any notion of a voluntary relinquishment of the privilege. Moreover, any evidence that the accused was threatened, tricked, or cajoled into a waiver will, of course, show that the defendant did not voluntarily waive his privilege. The requirement of warnings and waiver of rights is a fundamental with respect to the Fifth Amendment privilege and not simply a preliminary ritual to existing methods of interrogation. The warnings required and the waiver necessary in accordance with our opinion today are, in the absence of a fully effective equivalent, prerequisites to the admissibility of any statement made by a defendant. No distinction can be drawn between statements which are direct confessions and statements which amount to admissions of part or all of an offense. The privilege against self-incrimination protects the individual from being compelled to incriminate himself in any manner. It does not distinguish degrees of incrimination. Similarly, for precisely the same reason, no distinction may be drawn between inculpatory statements and statements alleged to be merely exculpatory. If a statement made were in fact truly exculpatory, it would, of course, never be used by the prosecution. In fact, statements merely intended to be exculpatory by the defendant are often used to impeach his testimony at trial or to demonstrate untruths in the statement given under interrogation, and thus to prove guilt by implication. These statements are incriminating in any meaningful sense of the word and may not be used without the full warnings and effective waiver required for any other statement. In Escobedo itself, the defendant fully intended his accusation of another as the slayer to be exculpatory as to himself. The principles announced today deal with the protection which must be given to the privilege against self-incrimination when the individual is first subjected to police interrogation while in custody at the station or otherwise deprived of his freedom of action in any significant way. It is at this point that our adversary system of criminal proceedings commences, distinguishing itself at the outset from the inquisitorial system recognized in some countries. Under the system of warnings we delineate today, or under any other system which may be devised and found effective, the safeguards to be erected about the privilege against self-incrimination must come into play at this point, the interrogation. Our decision is not intended to hamper the traditional function of police officers in investigating crime. When an individual is in custody on probable cause, the police may, of course, seek out evidence in the field to be used at trial against him. Such investigation may include inquiry of persons not under restraint, general on-the-scene questioning as to facts surrounding a crime, or other general questioning of citizens in the fact-finding process is not affected by our holding. It is an act of responsible citizenship for individuals to give whatever information they may have to aid in law enforcement. In such situations, the compelling atmosphere inherent in the process of in-custody interrogation is not necessarily present. In dealing with statements obtained through interrogation, we do not purport to find all confessions inadmissible. Confessions remain a proper element in law enforcement. Any statement given freely and voluntarily without any compelling influences is, of course, admissible in evidence. The fundamental import of the privilege against self-incrimination while an individual is in custody is not whether he is allowed to talk to the police without the benefit of warnings and counsel, but whether he can be interrogated. There is no requirement that police stop a person who enters a police station and states that he wishes to confess to a crime, or a person who calls the police to offer a confession or any other statement he desires to make. Volunteered statements of any kind are not barred by the Fifth Amendment, and their admissibility is not affected by our holding today. To summarize, we hold that when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subjected to questioning, the privilege against self-incrimination is jeopardized. Procedural safeguards must be employed to protect the privilege, and unless other fully effective means are adopted to notify the person of his right to silence and to assure that the exercise of the right will be scrupulously honored, the following measures are required. He must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. Opportunity to exercise these rights must be afforded to him throughout the interrogation. After such warnings have been given and such opportunity afforded him, the individual may knowingly and intelligently waive these rights and agree to answer questions or make a statement. But unless and until such warnings and waiver are demonstrated by the prosecution at trial, no evidence obtained as a result of interrogation can be used against him. Section 4 of Miranda v. Arizona. A recurrent argument made in these cases is that society's need for interrogation outweighs the privilege against self-incrimination. This argument is not unfamiliar to the Supreme Court. The whole thrust of our foregoing discussion demonstrates that the Constitution has prescribed the rights of the individual when confronted with the power of government, when it provided in the Fifth Amendment that an individual cannot be compelled to be a witness against himself. That right cannot be abridged. As Mr. Justice Brandeis once observed, quote, "Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizen. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of the criminal law the end justifies the means would bring terrible retribution. Against that pernicious doctrine, this Supreme Court should resolutely set its face." Close quote. That's from Olmstead v. United States, U.S. Supreme Court decision 1928. That is a dissenting opinion. Continuing now with this opinion. In this connection, one of our country's distinguished jurists has pointed out, quote, "The quality of a nation's civilization can be largely measured by the methods it uses in the enforcement of its criminal law." Close quote. If the individual desires to exercise his privilege, he has the right to do so. This is not for the authorities to decide. An attorney may advise his client not to talk to the police until he has had an opportunity to investigate the case, or he may wish to be present with his client during any police questioning. In doing so, an attorney is merely exercising the good professional judgment he has been taught. This is not cause for considering the attorney a menace to law enforcement. He is merely carrying out what he is sworn to do under his oath, to protect, to the extent of his ability, the rights of his client. In fulfilling this responsibility, the attorney plays a vital role in the administration of criminal justice under our Constitution. In announcing these principles, we are not unmindful of the burdens which law enforcement officials must bear, often under trying circumstances. We also fully recognize the obligation of all citizens to aid in enforcing the criminal laws. This court, while protecting individual rights, has always given ample latitude to law enforcement agencies in the legitimate exercise of their duties. The limits we have placed on the interrogation process should not constitute an undue interference with a proper system of law enforcement. As we have noted, our decision does not in any way preclude police from carrying out their traditional investigatory functions. Although confessions may play an important role in some convictions, the cases before us present graphic examples of the overstatement of the need for confessions. In each case, authorities conducted interrogations ranging up to 5 days in duration, despite the presence, through standard investigative practices, of considerable evidence against each defendant. Further examples are chronicled in our prior cases. See Haynes v. Washington, U.S. Supreme Court 1963, Rogers v. Richmond, U.S. Supreme Court 1961, Belinsky v. New York, U.S. Supreme Court 1945. It is also urged that an unfettered right to detention for interrogation should be allowed because it will often redound to the benefit of the person questioned. When police inquiry determines that there is no reason to believe that the person has committed any crime, it is said, he will be released without need for further formal procedures. The person who has committed no offense, however, will be better able to clear himself after warnings with counsel present than without. It can be assumed that in such circumstances, a lawyer would advise his client to talk freely to police in order to clear himself. Custodial interrogation, by contrast, does not necessarily afford the innocent an opportunity to clear themselves. A serious consequence of the present practice of the interrogation alleged to be beneficial for the innocent is that many arrests for investigation subject large numbers of innocent persons to detention and interrogation. In one of the cases before us, case number 584, California v. Stewart, police held 4 persons who were in the defendant's house at the time of the arrest in jail for 5 days until defendant confessed. At that time, they were finally released. Police stated that there was, quote, no evidence to connect them with any crime, close quote. Available statistics on the extent of this practice, where it is condoned, indicate that these 4 are far from alone in being subjected to arrest, prolonged detention, and interrogation without the requisite probable cause. Over the years, the Federal Bureau of Investigation has compiled an exemplary record of effective law enforcement while advising any suspect or arrested person at the outset of an interview that he is not required to make a statement, that any statement may be used against him in court, that the individual may obtain the services of an attorney of his own choice, and, more recently, that he has a right to free counsel if he is unable to pay. A letter received from the Solicitor General in response to a question from the bench makes it clear that the present pattern of warnings and respect for the rights of the individual followed as a practice by the FBI is consistent with the procedure which we delineate today. It states, quote, at the oral argument of the above cause, Mr. Justice Fortas asked whether I could provide certain information as to the practices followed by the Federal Bureau of Investigation. I have directed these questions to the attention of the Director of the Federal Bureau of Investigation, and I'm submitting herewith a statement of the questions and the answers which we have received. Question. When an individual is interviewed by agents of the Bureau, what warning is given him? Answer. The standard warning, long given by special agents of the FBI to both suspects and persons under arrest, is that the person has a right to say nothing and a right to counsel, and that any statement he does make may be used against him in court. After passage of the Criminal Justice Act of 1964, which provides free counsel for federal defendants unable to pay, we added to our instructions to special agents the requirement that any person who is under arrest for an offense under FBI jurisdiction, or whose arrest is contemplated following the interview, must also be advised of his right to free counsel if he is unable to pay, and the fact that such counsel will be assigned by the judge. At the same time, we broadened the right to counsel warning to read counsel of his own choice or anyone else with whom he might wish to speak. Question. When is the warning given? Answer. The FBI warning is given to a suspect at the very outset of the interview. The warning may be given to a person arrested as soon as practical after the arrest, but in any event, it must precede the interview with the person for a confession or admission of his own guilt. Question. What is the Bureau's practice in the event that the individual requests counsel and counsel appears? Answer. When the person who has been warned of his right to counsel decides that he wishes to consult with counsel before making a statement, the interview is terminated at that point. It may be continued, however, as to all matters other than the person's own guilt or innocence. If he is indecisive in his request for counsel, there may be some question on whether he did or did not waive counsel. Situations of this kind must necessarily be left to the judgment of the interviewing agent. For example, in Hiram v. U.S., Federal Court Decision 1965, Appellate Court, the agent's conclusion that the person arrested had waived his right to counsel was upheld by the courts. A person being interviewed and desiring to consult counsel by telephone must be permitted to do so. When counsel appears in person, he is permitted to confer with his client in private. Question: what is the Bureau's practice if the individual requests counsel but cannot afford to retain an attorney? Answer: if any person being interviewed after warning of counsel decides that he wishes to consult with counsel before proceeding further, the interview is terminated, as shown above. FBI agents do not pass judgment on the ability of the person to pay for counsel. They do, however, advise those who have been arrested for an offense under FBI jurisdiction or whose arrest is contemplated following the interview of a right to free counsel if they are unable to pay, and the availability of such counsel from the judge. Close quote. The practice of the FBI can readily be emulated by state and local enforcement agencies. The argument that the FBI deals with different crimes that are dealt with by state authorities does not mitigate the significance of the FBI experience. The experience in some other countries also suggests that the danger to law enforcement in curbs on interrogation is overplayed. The English procedure since 1912 under the judge's rules is significant. As recently strengthened, the rules require that a cautionary warning be given an accused by a police officer as soon as he has evidence that affords reasonable grounds for suspicion. They also require that any statement made be given by the accused without questioning by police. The right of the individual to consult with an attorney during this period is expressly recognized. The safeguards present under Scottish law may be even greater than in England. Scottish judicial decisions bar use and evidence of most confessions obtained through police interrogation. In India, confessions made to police not in the presence of a magistrate have been excluded by rule of evidence since 1872, at a time when it operated under British law. Identical provisions appear in the Evidence Ordinance of Ceylon, enacted in 1895. Similarly, in our country, the Uniform Code of Military Justice has long provided that no suspect may be interrogated without first being warned of his right not to make a statement, and that any statement he makes may be used against him. Denial of the right to consult counsel during interrogation has also been proscribed by military tribunals. There appears to have been no marked detrimental effect on criminal law enforcement in these jurisdictions as a result of these rules. Conditions of law enforcement in our country are sufficiently similar to permit reference to this experience as assurance that lawlessness will not result from warning an individual of his rights or allowing him to exercise them. Moreover, it is consistent with our legal system that we give at least as much protection to these rights as is given in the jurisdictions described. We deal in our country with rights grounded in a specific requirement of the Fifth Amendment of the Constitution, whereas other jurisdictions arrived at their conclusions on the basis of principles of justice, not so specifically defined. It is also urged upon us that we withhold decision on this issue until state legislative bodies and advisory groups have had an opportunity to deal with these problems by rulemaking. We have already pointed out that the Constitution does not require any specific code of procedures for protecting the privilege against self-incrimination during custodial interrogation. Congress and the states are free to develop their own safeguards for the privilege, so long as they are fully as effective as those described above in informing accused persons of their right of silence and in affording a continuous opportunity to exercise it. In any event, however, the issues presented are of constitutional dimensions and must be determined by the courts. The admissibility of a statement in the face of a claim that it was obtained in violation of the defendant's constitutional rights is an issue the resolution of which has long since been undertaken by this Supreme Court. Judicial solutions to problems of constitutional dimension have evolved decade by decade. As courts have been presented with the need to enforce constitutional rights, they have found means of doing so. That was our responsibility when Escobedo was before us, and it is our responsibility today. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Section 5 of Miranda v. Arizona. Because of the nature of the problem and because of its recurrent significance in numerous cases, we have to this point discussed the relationship of the Fifth Amendment privilege to police interrogation without specific concentration on the facts of the cases before us. We turn now to these facts to consider the application to these cases of the constitutional principles discussed above. In each instance, we have concluded that statements were obtained from the defendant under circumstances that did not meet the constitutional standards for protection of the privilege. Case number 759, Miranda v. Arizona. On March 13, 1963, petitioner Ernesto Miranda was arrested at his home and taken in custody to a Phoenix police station. He was there identified by the complaining witness. The police then took him to interrogation room number 2 of the Detective Bureau. There he was questioned by 2 police officers. The officers admitted at trial that Miranda was not advised that he had a right to have an attorney present. 2 hours later, the officers emerged from the interrogation room with a written confession signed by Miranda. At the top of the statement was a typed paragraph stating that the confession was made voluntarily, without threats or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. At his trial before a jury, the written confession was admitted into evidence over the objection of defense counsel, and the officers testified to the prior oral confession made by Miranda during the interrogation. Miranda was found guilty of kidnapping and rape. He was sentenced to 20 to 30 years imprisonment on each count, the sentences to run concurrently. On appeal, the Supreme Court of Arizona held that Miranda's constitutional rights were not violated in obtaining the confession and affirmed the conviction. In reaching its decision, the court emphasized heavily the fact that Miranda did not specifically request counsel. We, the U.S. Supreme Court, reversed that conviction. From the testimony of the officers and by admission of respondent, it is clear that Miranda was not in any way apprised of his right to consult with an attorney and to have one present during interrogation. Nor was his right not to be compelled to incriminate himself effectively protected in any other manner. Without these warnings, the statements were inadmissible. The mere fact that he signed a statement which contained a typed-in clause stating that he had quote-unquote full knowledge of his quote-unquote legal rights does not approach the knowing and intelligent waiver required to relinquish constitutional rights. Case number 760, Vignera v. New York. Petitioner Michael Vignera was picked up by New York police on October 14, 1960, in connection with the robbery 3 days earlier of a Brooklyn dress shop. They took him to the 17th Detective Squad headquarters in Manhattan. Sometime thereafter, he was taken to the 66th Detective Squad. There, a detective questioned Vignera with respect to the robbery. Vignera orally admitted the robbery to the detective. The detective was asked on cross-examination at trial by defense counsel whether Vignera was warned of his right to counsel before being interrogated. The prosecution objected to the question, and the trial judge sustained the objection. Thus, the defense was precluded from making any showing that warnings had not been given. While at the 66th Detective Squad, Vignera was identified by the store owner and a sales lady as the man who robbed the dress shop. At about 3 p.m., he was formally arrested. The police then transported him to still another station, the 70th Precinct in Brooklyn, for detention. At 11 p.m., Vignera was questioned by an assistant district attorney in the presence of a hearing reporter who transcribed the questions and Vignera's answers. The verbatim account of these proceedings contains no statement of any warnings given by the assistant district attorney. At Vignera's trial on a charge of first-degree robbery, the detective testified as to the oral confession. The transcription of the statement taken was also introduced in evidence. At the conclusion of the testimony, the trial judge instructed the jury in part as follows, quote, "The law doesn't say that the confession is void or invalidated because the police officer didn't advise the defendant as to his rights. Did you hear what I said? I'm telling you what the law of the state of New York is." Close quote. Vignera was found guilty of first-degree robbery. He was subsequently adjudged a third felony offender and sentenced to 30 to 60 years imprisonment. The conviction was affirmed without opinion by the Appellate Division, 2nd Department, and by the Court of Appeals, also without opinion. In argument to the Court of Appeals, the state contended that Vignera had no constitutional right to be advised of his right to counsel or his privilege against self-incrimination. We, the U.S. Supreme Court, reverse this conviction. The foregoing indicates that Vignera was not warned of any of his rights before the questioning by the detective and by the assistant district attorney. No other steps were taken to protect these rights. Thus, he was not effectively apprised of his Fifth Amendment privilege against self-incrimination or of his right to have counsel present, and his statements, confessions, are inadmissible. Case number 761, Westover v. United States. At approximately 9:45 p.m. on March 20th, 1963, petitioner Carl Calvin Westover was arrested by local police in Kansas City as a suspect in 2 Kansas City robberies. A report was also received from the FBI that he was wanted on a felony charge in California. The local authorities took him to a police station and placed him in a lineup on the local charges, and at about 11:45 p.m. he was booked. Kansas City police interrogated Westover on the night of his arrest. He denied any knowledge of criminal activities. The next day, local officers interrogated him again throughout the morning. Shortly before noon, they informed the FBI that they were through interrogating Westover and that the FBI could proceed to interrogate him. There is nothing in the record to indicate that Westover was ever given any warning as to his rights by local police. At noon, 3 special agents of the FBI continued the interrogation in a private interview room of the Kansas City Police Department, this time with respect to the robbery of a savings and loan association and a bank in Sacramento, California. After 2.5 hours, Westover signed separate confessions to each of these 2 robberies, which had been prepared by one of the agents during the interrogation. At trial, one of the agents testified, and a paragraph on each of the statements states that the agents advised Westover that he did not have to make a statement, that any statement he made could be used against him, and that he had a right to see an attorney. Westover was tried by jury in federal court and convicted of the California robberies. His statements were introduced at trial. He was sentenced to 15 years imprisonment on each count, the sentences to run consecutively. On appeal, the conviction was affirmed by the Court of Appeals for the Ninth Circuit. We, the U.S. Supreme Court, reverse this conviction. On the facts of this case, we cannot find that Westover knowingly and intelligently waived his right to remain silent and his right to consult with counsel prior to the time he made the statement. At the time the FBI agents began questioning Westover, he had been in custody for over 14 hours and had been interrogated at length during that period. The FBI interrogation began immediately upon the conclusion of the interrogation by Kansas City police and was conducted in local police headquarters. Although the 2 law enforcement authorities are legally distinct and the crimes for which they interrogated Westover were different, the impact on him was that of a continuous period of questioning. There is no evidence of any warning given prior to the FBI interrogation, nor is there any evidence of an articulated waiver of rights after the FBI commenced its interrogation. The record simply shows that the defendant did not, in fact, confess a short time after being turned over to the FBI following interrogation by local police. Despite the fact that the FBI agents gave warnings at the outset of their interview, from Westover's point of view, the warnings came at the end of the interrogation process. In these circumstances, an intelligent waiver of constitutional rights cannot be assumed. We do not suggest that law enforcement authorities are precluded from questioning any individual who has been held for a period of time by other authorities and interrogated by them without appropriate warnings. A different case would be presented if an accused were taken into custody by the second authority, removed both in time and place from his original surroundings, and then adequately advised of his rights and given an opportunity to exercise them. But here, the FBI interrogation was conducted immediately following the state interrogation in the same police station, in the same compelling surroundings. Thus, in obtaining a confession from Westover, the federal authorities were the beneficiaries of the pressure applied by the local in-custody interrogation. In these circumstances, the giving of warnings alone was not sufficient to protect the privilege against self-incrimination. Case number 584, California v. Stewart. In the course of investigating a series of purse snatch robberies in which one of the victims had died of injuries inflicted by her assailant, respondent Roy Allen Stewart was pointed out to Los Angeles police as the endorser of dividend checks taken in one of the robberies. At about 7:15 p.m., January 31st, 1963, police officers went to Stewart's house and arrested him. One of the officers asked Stewart if they could search the house, to which he replied, "Go ahead." The search turned up various items taken from the 5 robbery victims. At the time of Stewart's arrest, police also arrested Stewart's wife and 3 other persons who were visiting him. These 4 were jailed along with Stewart and were interrogated. Stewart was taken to the University Station of the Los Angeles Police Department, where he was placed in a cell. During the next 5 days, police interrogated Stewart on 9 different occasions. Except during the first interrogation session, when he was confronted with an accusing witness, Stewart was isolated with his interrogators. During the 9th interrogation session, Stewart admitted that he had robbed the deceased and stated that he had not meant to hurt her. Police then brought Stewart before a magistrate for the first time. Since there was no evidence to connect them with any crime, the police then released the other 4 persons arrested with him. Nothing in the record specifically indicates whether Stewart was or was not advised of his right to remain silent or his right to counsel. In a number of instances, however, the interrogating officers were asked to recount everything that was said during the interrogations. None indicated that Stewart was ever advised of his rights. Stewart was charged with kidnapping to commit robbery, rape, and murder. At his trial, transcripts of the first interrogation and the confession at the last interrogation were introduced in evidence. The jury found Stewart guilty of robbery and first-degree murder and fixed the penalty as death. On appeal, the Supreme Court of California reversed. It held that under this court's decision in Escobedo, Stewart should have been advised of his right to remain silent and of his right to counsel, and that it would not presume in the face of a silent record that the police advised Stewart of his rights. We, the U.S. Supreme Court, affirm this reversal of the conviction by the California Supreme Court. In dealing with custodial interrogation, we will not presume that a defendant has been effectively apprised of his rights and that his privilege against self-incrimination has been adequately safeguarded on a record that does not show that any warnings have been given or that any effective alternative has been employed. Nor can a knowing and intelligent waiver of these rights be assumed on a silent record. Furthermore, Stewart's steadfast denial of the alleged offenses through 8 of the 9 interrogations over a period of 5 days is subject to no other construction than that he was compelled by his persistent interrogation to forego his Fifth Amendment privilege. Therefore, in accordance with the foregoing, the judgments of the Supreme Court of Arizona in case number 759, of the New York Court of Appeals in case number 760, and of the Court of Appeals for the Ninth Circuit in number 761 are reversed. The judgment of the Supreme Court of California in case number 584 is affirmed. It is so ordered. All right, folks, that's the conclusion of our reading of part 2 of 4 of Miranda of Arizona, the second half of the majority opinion. In part 3, which comes up next, we begin reading the 3 dissents in Miranda v. Arizona. The 3 dissents were written by various combinations of the 4 justices. This was a 5-4 decision. And the first 2 of those dissents we'll read in part 3 of 4, which is next. I'm looking forward to sharing that with you, and I'll see you all there. Until then, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.